A big legal update in the non-compete ban in the US. What happened? I'll break it down. So the FTC, the Federal Trade Commission's ban on non-competes in the US is scheduled to take effect September 4th. But there are 3 legal challenges in different federal courts in the US seeking to halt that ban so that employers that can use non-competes could still use those. And those cases are in Texas, Pennsylvania, and Florida. And I'm going to talk about the Florida case. So in that case, it's brought by the Villages retirement community, actually properties of the Villages, which is the real estate arm. And why it's notable is that the Villages, so for their real estate agents, they have a provision in their contract that if they leave employment, they can't go do real estate inside the Villages for another entity for 2 years, 24 months. And in their filings, their legal filings, they call it a relatively short cooling off period. And so when this rule came out, the Villages filed a suit seeking 2 things. One, asking the court to say, hey, this ban is illegal, that the FTC doesn't have the legal authority to issue such a sweeping ban against us, the Villages, so don't worry about any other employers, but just us. It shouldn't apply to us. And they also ask, this is so illegal, it shouldn't apply to any employers that can otherwise use non-competes in the US. And so both like a narrow kind of ruling, and they're also seeking a nationwide ban. Why this is also notable is that a lot of times in comments, or I'll hear people say, like, you can't enforce a non-compete, or it's really hard to enforce. Well, the Villages went through a legal challenge to their non-competes just a few years ago. They had real estate agents that left and were working with another entity to sell real estate in the Villages in violation of that non-compete period. And they went to court, and it went back and forth, and I can guarantee you very expensive legal bills, but after all the litigation, the court held that the non-compete, that 2-year non-compete in the Villages was reasonable and it was to be enforced. And so those agents then had to live within that non-compete. They had to give up customer lists and all of those things. So the Villages had already had a successful challenge where their non-compete was ruled reasonable. So an example of where non-competes have been upheld in court. And there are plenty of those all over the country where non-competes are held. So that's why this rule really would matter if it would strike down non-competes. So Villages filed this suit. Yesterday there was a hearing in federal court. And often what happens in hearings is, these parties give their sides. And I think this hearing was about 2.5 hours long. I wasn't there, but in these hearings, people back and forth. Rarely at the end of a hearing like this does a judge give their order. Normally they'll say, oh, we'll take it under advisement. It's like, I'll go back, sit with my clerks, we'll think about it, etc. Well, at the end of this hearing yesterday, the judge there actually said, we're going to grant your motion, the Villages. So they're going to halt non-competes, but just against the Villages. And they've said, your non-compete has already been deemed reasonable. They find that this rule by the FTC exceeds its authority. And so all right now we have is this. This is just a 1-page minutes of the hearing, so just saying it's granted. So when I first looked at this, I was thinking, oh, is this just against the Villages? Or is this a nationwide stay, which would be bigger news because it would impact everybody? But the AP did reporting that said that the judge had said, no, this is just for the Villages, but I am finding this halted. It's called a preliminary injunction against this rule taking effect for the Villages. This won't affect any other employers. But why this is so notable is that, so this Florida case now, you have this narrow ruling, and that means the case goes on. So the judge may ultimately decide what's called on the merits of whether this ban is legal or illegal, but that's likely going to, it's almost definitely going to extend well beyond the September 4th effective date. So like the non-compete ban would take effect for other employers on that date. But why it's notable is you have those Texas and Pennsylvania courts. And I've done videos on this, but the Texas case did a similar thing. So that's by a much larger company and has a few other organizations that have signed on. But there, in July, the judge there did the same thing that the judge in Florida did, that said, hey, we're going to halt this from taking effect for you specific employers. We're not going to have a nationwide ban yet. But the judge said, we are going to issue a merits decision by August 30th. So 5 days, I have to think about how many days August had. 5 days before the ban takes effect, I will issue a merits decision. And so the judge there will decide whether or not to have a nationwide ban on this, on the non-compete, or nationwide halt on the non-compete ban taking effect. And so the Pennsylvania case, there the judge actually struck down and did not agree with the company's motion there for a preliminary injunction. Again, that was a very small tree company, and the judge there had said, you have not met the grounds for a preliminary injunction, so the FTC's rule can go forward. So you have these different decisions. So that leads to what's called a circuit split, and so in court, this is where people may be appealing to the courts of appeal. So you're likely having lawyers that are doing these appeals, but the notable date for employees and employers who are looking at this non-compete ban, the one certain date is September 4th, when it's supposed to take effect, which then employers have to send notices to employees that have non-competes saying, hey, your non-compete is no longer valid. That's one of the reasons employers are really watching this, because not only do they need to know whether or not they can have them in their existing agreements, but they also have to send out a notice. But so September 4th, yes, that is the date it's supposed to take effect. But August 30th is the date that Judge Ada Brown, in the Texas case, Ryan LLC versus the FTC, has said she will issue a merits decision. And I'd gone back and reread her initial decision where she'd halted the ban temporarily for a group of employers. And her language, to me, very much reads that she finds it likely overbroad. But we will see what she says then and whether there is a nationwide ban. So all of those people that are saying non-competes are going to be illegal soon, this case in Texas is really the one most to watch about whether that actually happens. And that's where anyone hoping that non-competes will no longer be a thing could potentially be disappointed on August 30th if the ban is struck down on a nationwide basis. And again, then it just goes to court and appeals and all of these things. But if it ultimately ends up in the Supreme Court, which can often happen when you have different courts like Pennsylvania having a different ruling than Texas and Florida, those things can potentially end up at the Supreme Court. And with the current makeup of the Supreme Court, most legal experts that are looking at this have said they ultimately expect that non-compete ban will not take effect. But it's really important to just have a sense of what's going on. So hopefully that breakdown is helpful.